What happens if the defense attorney makes a promise to me during the course of settlement negotiations and then breaks his promise? Would you like to know what this is all about? Come join me for a walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. So now you brought a lawsuit seeking compensation, seeking money as a form of compensation for all the harms and losses and damages that you incurred as a result of a doctor's carelessness. Your case has been going on for 2 years, and now the defense finally comes to your attorney and says, hey, listen, we'd like to start negotiating. Now, during the course of negotiation, the defense attorney has made multiple offers, and your attorney has made multiple counteroffers. The last conversation that your attorney had went as follows. Hey, Gerry, listen, if I can get you $2 million, will this case settle? And now we've gone back and forth. We initially started negotiations where we were demanding $5 million, knowing full well that that far exceeded the true value of your injuries. The defense at the very beginning came in with a very low number and slowly made their way up to very close to $2 million. Now, as we were having this ongoing settlement discussion, the defense attorney turns to me and says, hey, listen, if I got you $2 million, will it settle the case? Now, that was my goal. I wanted to get to $2 million. My client knew and had agreed that if I was able to get $2 million, he would agree to settle the case at that point. We knew that his case was worth $2 million. Now, the defense attorney implied that he could make a phone call and basically guarantee that he could get me the full $2 million so we could settle this case. And it was more than an implication. It was more than, hey, listen, if I get this for you, will it settle the case? It was, look, I know your case is really worth $2 million, but I don't have the authority for it right now. I need to make a call and see if I can get that for you. And then he said, I just need to get authority, and then we can wrap this case up. So a few days later, he calls me back and says, listen, I can't get you the $2 million. I said, what are you talking about? You basically told me that all you needed to do was make a phone call, and now you'd be able to get the $2 million and put this case to bed. He said, no, I can't do it. The carrier will not agree. Therefore, the most I can get you is $1.75 million. I said, well, that's not going to do it. That's not going to do it at all, because you basically guaranteed and you basically implied that you had that money available. All you needed to do was finalize it by making a phone call. That's not right. Now, what happens in that instance where the defense attorney basically came out and not 100% guaranteed, but he certainly implied that the case was just about done. He just needed to get an approval by calling the right person, and that would be the end of it. Well, I'll tell you what happens. Now he's lost significant credibility with me. Now I know it's going to be very difficult for him to maintain any sort of credibility if we continue any further settlement discussions. At this point, settlement discussions have now broken down. I know I can no longer trust him and what he has to say. He basically told me this case would be done for $2 million. I just needed to get approval, and now he comes back and says, no, that's not going to happen. Now, could you argue that he was doing his best to try and get me the $2 million? Well, in this particular scenario, I'd say no. It's not as if I've been dealing with this guy for a long time and I knew him and have dealt with him in the past on other cases, and I trusted him implicitly. In this case, it was the first time I had been working with him, and now he makes this boast, literally a boast, that he could resolve this and wrap it up for $2 million. Instead, he comes back and says, no, 1.75. Now, I know what's going on here. I know he's doing everything possible to try and save some money off of what we believe the case is worth. I know he wants to look like a hero to his principals, to go back and say, look, Oginski got his client to accept less than what he originally wanted and what he originally said his client would take. In that instance, he now looks like a hero. He hopefully will get more business that way. And guess what? Now my client is out a substantial amount of money, all because this attorney had a different agenda. So in that instance, what happens next? When this case comes up for trial, the trial assignment judge may try and see if he can settle this case. He may try and get both sides together and say, look, you're only $250,000 apart. I need you to come up with X number of dollars. I need you to come down. And what happens if neither one of us are willing to budge? Well, the answer is pretty simple. We go forward and we go to trial. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding into what happens in these medical malpractice cases in New York. You know, I realize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.